The tribe says, hit the like.
Greetings and welcome to Public Funds from American Jurisprudence. Before we get started, just to remind everyone this is strictly for the educational entertainment purposes of this YouTube channel and broadcast, not to be used, misconstrued, or abused for anything personal, private, legal, lawful, business, tax, financial, or otherwise. So please don't do this at home. That said, welcome to everyone. Let's get started. All right, so we're going to be learning everything you never knew about public funds. We're going to go over the definitions and the nature of public funds, ownership and trust of those funds, lending restrictions, and fund transfers. So let's get started with the fund. So in general, will be sections 1 through 4. Deposits in general will be sections 5 through 7, and then depositories will be the remainder. That's the selection, security, bonds, sureties, federal depositories. And believe me, by the end of this presentation, this will all make perfect sense. Let's get started. So with section 1, we're going to go over the definition, nature, ownership, lending restrictions, transfers. We're starting with the definition and nature here. All those are at the bottom. Okay. Definition. Public funds are monies belonging to the United States or a corporate agency of the federal government. That's both capital letters, by the way. A state or subdivision thereof, or a municipal corporation. They represent monies raised by the operation of law for the support of the government or for the discharge of its obligations. They constitute revenue, defined as the income of the government arising from taxation, duties, and the like. So we see right here, it's a pretty interesting start here with what they actually are. They are revenue, they are monies. So public funds are monies used for support of the government and the discharge of its obligations, to relieve it of its obligations by paying money. The term public money sometimes includes not only state-owned funds, but also private money held by state officials in their official capacity. That's interesting there. So it could be private money held by state officials in their official capacity now becomes public money. The fact that the government has taken possession of monies, pursuant to law, is sufficient to constitute them government funds, even though they are held for a special purpose. So the key principle is that when the United States sets aside money for payment of specific debts, it does not lose its property interest in that money. So that's an interesting distinction. Just because something is bookmarked, so to speak, for something doesn't mean that the United States hasn't lost interest or having, which is essentially property, is ownership is a bundle of rights. So right there you see that just by earmarking something or specifying it for something doesn't necessarily mean you've lost possession or ownership. Let's move along. So the definition continued here in nature. Erroneously collected funds. Public funds include money erroneously collected but received under color of office. Wow. While it belongs to those who paid it, nevertheless the state, in whose name and by whose authority it was pretended to have been collected, is the proper custodian of it. Wow, so you're both the thief and the trustee. Observation: it has been held that the question of what constitutes public funds within the meaning of a federal statute governing depositories of federal funds does not depend upon whether the deposit secured redeemed public money according to the law of the state where the security was given. Rather, the matter is to be determined as a federal question. Before we can go any further, it seems that there's something we're leaving behind here. I keep seeing this word secure and security here that keeps appearing in a way that's not seemingly common language, which means it's a term. And if it's a term and we're not familiar, then that behooves us to visit Black's Law and find out what exactly they mean by this security. So we have 9th edition right here, and let's see if we can find out what they mean by this term of security. All right, so we have securities, and here's security. All right, it's a noun from the 15th century. Collateral given or pledged to guarantee the fulfillment of an obligation, especially the assurance that a creditor will be repaid, usually with interest, any money or credit extended to a debtor. So we have a person. Definition 2 is a person. A person. Now this doesn't have to be a natural person. It could be any kind of person here. Okay, so a person who is bound by some type of guarantee or surety. We'll come back to this. 3, the state of being secure from danger or attack. That's more of a common definition. 4, an instrument. An instrument written that evidences the holder's ownership rights in a firm. An example given is a stock. The holder's creditor relationship with a firm or government. Example given here is a bond. Or the holder's other rights. The example given here is an option, meaning that there's an open window for an acceptance in which an offer cannot be withdrawn. You have the option to either accept it or not accept it within that period of time. That's an option. And a security indicates an interest based on an investment in a common enterprise. Common enterprise rather than direct participation in the enterprise. We've seen this before here. Interest based on an investment in a common enterprise rather than direct participation in the enterprise. We're talking here about security. All right, let's continue on. Under an important statutory definition, a security is any interest or instrument relating to finances. Any interest or instrument relating to finances is a security, including a note, stock, treasury stock, bond, debenture, evidence of indebtedness, certificate of interest, or participation in a profit-sharing agreement. So these are important here. Certificates of participation or certificate of interest in a profit-sharing agreement, collateral trust certificate, pre-organization certificate or subscription, transferable share, investment contract, voting trust certificate, certificate of deposit for a security. It's your CDs, fractional undivided interest in oil or gas or other mineral rights, or a certificate of interest in or participation in temporary or interim certificate for receipt for guarantee of or warranty or right to subscribe to or purchase any of these things. Things, again, subject matter of rights or interests. A security also includes any put, call, straddle, option, or privilege on any security, certificate of deposit, group of indexes of securities, or any such device entered into on a national securities exchange relating to foreign currency. Also termed evidence of indebtedness, evidence of debt. Wow, so that's a security is evidence of indebtedness or evidence of a debt. All right, so securities differ. This is where it gets good now. We read all the dry stuff. Now it's all going to come together that we've surpassed that. And if you just arrived, please do hit the like if you haven't already. And I believe we have the talking chat enabled here.
The crime says, hit the like.
Indeed we do. So that way we can participate. I don't know if you heard that there. Let's get it so it does talk. Let's try that one more time.
The crime says, hit the like.
All right, I believe we heard that one. Let's move along. All right, where did it go? Okay, securities differ from most other commodities in which people deal. So they have no intrinsic value in themselves. They represent rights in something else. So securities are things, huh? The value of a bond, note, or other promise to pay depends on the financial condition of the promisor. The value of a share of stock depends on the profitability or future prospects of the corporation or other entity which issued it. Now, before we go, that future prospects is interesting here because the future is uncertain. Let me proceed. Its market price depends on how much other people are willing to pay for it. There we go. That's a market price. How much other people are willing to pay for it based on their evaluation of those prospects. What do the following have in common? Scotch whiskey, self-improvement courses, cosmetics, earthworms, beavers, muskrats, rabbits, chinchillas, fishing boats, vacuum cleaners, cemetery lots, cattle embryos, master recording contracts, animal feeding programs, pooled litigation funds. Ooh, whoa. Pooled litigation funds? Huh. And fruit trees. The answer is that they have all been held to be securities within the meaning of federal or state security statutes. The vast range of such unconventional investments that have fallen within the ambit of the securities law's coverage is due to the broad statutory definition of a security. Wow. So that's a pretty long-winded definition here, and we see adjustment securities, assembled securities, equity securities, exempt securities. What's an exempt security? That's a security that need not be registered under the provisions of the Security Act. Wow. Would be a good example of that. I'd like to see that. But as you see here, we have all kinds of asset-backed security, a debt security such as a bond that is secured by assets that have been pooled and secured by the assets from the pool. So it's a bond that is secured by assets. Wow, that's really getting deep. And we have things like mortgage-backed securities. So it's a security, especially a pass-through security, another security here, a pass-through backed by mortgages. The cash flow from these securities depends on the principal and interest payments from the pool of mortgages. See stripped mortgage-backed security. And this pass-through security seems rather interesting too. Here it is, pass-through security. A security that passes through payments from debtors to investors. Whoa, so this mortgage-backed security is something that the cash flow from the mortgage to the security here, to the investors of the pool of mortgages. Pass-through securities are usually assembled and sold in packages to investors by private lenders who deduct a service fee, no kidding, before passing the principal and interest payments through to the investors. Now that's pretty interesting there. I guess that kind of takes us to something else here. Two things we want to do here. As we saw before, there's a word guarantee and surety back here. I promised we'd get back to here. So we have a person who is bound by some type of guarantee or surety. So what do they mean by this? Is another one to dig a little deeper. So let's consult Black's Law for what does it mean by a guarantee? And if we can find it here. All right, it's a few more pages down here. Actually, quite a few more because, oops, that's too many. All right, bear with me here. It's a scanned document here, so scrolling wasn't a good idea. Let's see, guarantee. Give me a second here. Let's find it quicker like this. Oh, okay, maybe it's this. Nope. There we go. All right, bear with me a moment here. We'll be there in just a second. Come on. All right, almost there. Well, maybe it's here. Nope. Okay, we're gonna scroll from here. Oh, wait a second. What are we on here? H. Okay, yeah, so problem is when they have the words like we were just reading there with securities, there's some that come. There we go. All right, now we're close. Here's guarantee with the E, and we're looking for guarantee with a Y. Here it is. Guarantee, 16th century, a promise to answer for the payment of some debt or the performance of some duty in case of the failure of another who is liable in the first instance. So a guarantee could be even the performance of some duty in the case of failure of another who is liable in the first instance. The term is most common in finance and banking contexts, while a warranty relates to things, not persons. So things is could be persons, but in this case, excluding persons. So any other kind of subject matter that involves rights and interests would be the thing. Is not collateral and need not be in writing. A guarantee, so the warranty need not be in writing, right? Implied warranties. A guarantee is an undertaking that a person will pay or do some act, is collateral to the duty of the primary obligor, and must be in writing. So here's a little something, I guess, that incorporates that statute of fraud, whereas in a warranty, it doesn't necessarily need to be in writing to have the force of law, whereas a guarantee does. All right, must be in writing. On the spelling of the guarantee versus guarantee, see the quotation at guarantee. We'll check that, of course, but let's first read what we have here in the inset. Both guarantee and warranty are undertakings by one party to another to indemnify the party assured against some possible default or defect. So indemnify, to hold harmless, but a guarantee relates to the future as a collateral promise designated to protect the promisee from loss in case another fails to perform his duty. A warranty relates to the present or the past and is an independent promise designed to protect the promisee from loss in the event that the facts warranted are not as the promisor states them to be when the contract is made. A warranty is broken as soon as it is made if the facts are not represented, and is enforceable through oral, whereas a guarantee is not breached until a future default occurs and is unenforceable unless in writing. So the warranty, let's see here. So our distinction here is broken as soon as it is made if the facts are not as represented. So warranty is saying that everything you present is true. If it's later found out, the warranty now is made. So it's basically a warranty is that type of a promise that facts are true and correct, whereas the guarantee is not breached until a future default occurs. So the guarantee is the warranty is basically more of a confidence factor that something is as it says is warranted, right? But a guarantee is saying that if, and there's a possibility, so there is a probability, even a likelihood, whereas a warranty, something being defective, is not an intention. Guarantee could be something where there is intention to take risk, and it's not breached until a future default occurs and is unenforceable unless in writing for those very purposes. A transaction of guarantee involves at least three parties: a promisor, a creditor, the person to whom the promise is made, and a debtor. Although at the time the promise is made, the person denominated the creditor need not have extended the credit to the person denominated as the debtor. The usual guarantee situation arises when the promisor makes a promise to the creditor either as to the solvency of the debtor or as to the payment of the debt. So the usual guarantee situation arises when the promisor makes a promise to the creditor as to the solvency of the creditor or as a payment of the debt. Okay. So we have all kinds of guarantees here, but we're going to have to look to the word of guarantee to find out why it's spelled two different ways. And here it is here. Well, we have a verb version of it, but I don't think we're looking for the noun version. Here it is. Guarantee, the assurance that a contract or legal act will be duly carried out, duly according to law. And guarantee, it says here, in practice, guarantee is the usual term seen often, for example, in the context of consumer warranties or other assurances of quality or performance. Guarantee, in contrast, is now used primarily in financial and banking contexts in the sense a promise to answer for a debt of another. Guarantee is now rarely seen in non-legal writing, whether in Great Britain or in the US, and that's from Brian Garner. We covered some of his writings too on this channel. Okay, so we see here that the guarantee, here's our way of knowing. Greetings and welcome. I guess the emojis don't speak here with the talking chat. It has to be actual text, but thank you there. So let's continue on here. The guarantee is typically going to be used in financial and is essentially a promise to answer for a debt of another. And a regular guarantee we see here for consumer context involves warranties and assurances of quality or performance, not to answer for debts. So I think that's the big thing there. Just think, are you answering for a debt or is it in the context of quality or performance? So that's the big difference when we use these terms. Guarantee is the term we're going to be using for this presentation. The But that brings us to another word here that kind of bugged me. We saw it called lender. And we see lend, and that comes from before the 12th century. This to allow the temporary use of something, sometimes in exchange for compensation, on condition that the thing or its equivalent be returned. On condition. So that's essential there. 2, to provide money temporarily on condition of repayment, usually with interest. And here we are, lender, a person or entity from which something, especially money, is borrowed. All right, so there it is. We get the lend and lender part down there. And I believe that takes us back to our presentation. Thank you for coming with me on that little digression. Let's proceed. So now, as we read the observation, it should make more sense. It has been held that the question of what constitutes public funds within the meaning of a federal statute governing depositories of federal funds does not depend on whether the deposits secured were deemed public money according to the law of the state where the security was given. Rather, the matter is to be determined as a federal question. And as we go to, again, where we saw security in this context being used, oops, we should be able to get right back to that one. All right. Collateral given or pledged to guarantee the fulfillment of an obligation, right? And a person who is bound by some type of guarantee is a security, but we're looking at the collateral given or pledged to guarantee fulfillment of an obligation. What obligation are we fulfilling here? So we're saying here, oops, there we go, public money according to where the security was given. So, has this been securitized? It has been held that the question of what constitutes public funds within the meaning of a federal statute governing depositories does not depend upon whether the deposits secured were deemed public money. Oh, okay, so depending where it's deposited, I see. As far as collateral, according to the law of the state where the security was given, rather the matter, so the deposit to the secured rather matters to be determined as a federal question. Oh boy. General rule here is money legally paid by the state ceases to be public money in the hands of the recipients. So money legally paid by the state ceases to be public money. However, federal grant money does not lose its public character simply because it is administered by a non-federal agency. And we've seen this a lot with federal grants that where there's a strings attached, so to speak, and they could be attached to certain types of, I guess you'd say, considerations or concessions by the other parties. So, yes, indeed, the federal funds never lose their public character. They stay as public funds even when they're in the hands of the recipients. But there's an exception when public money is used for private purposes in violation of the law. It retains its public funds as well. So there's our general rule, our federal grant, and our exceptions. So there's the way the public money can change its character. The same money, but as again, the interest in it changes. The ownership of public funds. So now we get to the ownership for non-specialists.
List B 2001 says, Oakland Love.
Greetings to Less TV. Yes, indeed. Trustees or agents means public officers do not own the funds. So when you're a trustee or an agent, means the public officers do not own the funds. They merely hold and manage them on behalf of the government body, which is for the people, of course. So they're just trustees or agents for the non-specialists. The key principle here is well established that public officers who have charge of public funds occupy the status merely of trustees or agents with respect to such funds. The beneficial interest in and ownership of public funds is vested in the state or other public body under whose authority and for whose benefit such funds have been received. So the ownership of public funds is vested in the state. So that means that vested, it's not where they started from. They are put into the state or public body's authority for the benefit such funds have been received. Supplement case here, we have the state was not an indispensable party in the stakeholders' interpleader action to resolve competing claims of the United States and state to fund, and thus dismissal of the action was not necessary after state's dismissal from case on 11th Amendment grounds after removal, even though stakeholder would continue to be subject to state's claims, where remand to state court would have resulted in the dismissal of the United States. Okay, so we're going to be getting to some diversity stuff too soon. Now we have prohibition against loan of public funds. This is where it gets rather interesting here for non-specialists. Lending credit means the government guarantees or backs private parties' financial obligation, similar to co-signing a loan. So we have here guarantees, but I think we're talking about acting as a guarantee or backs a private party's financial obligation. So they can answer for any kind of default in a private party here by lending that credit. Unless a valid statute authorizes it, a public agency has no right to loan public funds. Now, some state constitutions expressly prohibit the state, municipality, or other county from giving or lending its credit in furtherance of a private purpose or in aid of any person, association, or corporation. I'm sure there's not too many state constitutions that do that. I'd be interested to know which ones. It seems there's a lot of public-private types of credit exchanges these days. If a public interest is served, some courts hold that the prohibition against lending the state's credit is not violated. There it is. Public interest. So if you can convince a judge it's a public interest, there goes that prohibition. And our key principle is that the legislation created a housing authority to make mortgage money available for private home buying has been upheld as against contentions it violates the constitutional prohibition against lending the state's credit on the ground that such use is a public, not private use. Wow. However, there's also authority to the contrary, and some courts have held that the incidental economic benefits to the public do not justify lending public credit. Okay. As you see, there are opposing views. Check your jurisdiction. The narrow construction of credit clauses. Some courts have construed a credit clause as proscribing only suretyship on loan guarantee arrangements without affecting the borrowing by the state as primary debtor or the lending of state money as distinguished from state credit. Borrowing by the state as a primary debtor or lending of the state as distinguished from state credit. Wow. Only suretyship or loan guarantee arrangements without affecting the borrowing. Let's see, definition note. Suretyship is an arrangement where one party guarantees performance of another's obligation, essentially promising to pay if the other party defaults. So we have suretyship, but what's the difference from a guarantee there? But let's read on here. Supplement case. There is no lending of credit where revenue bonds issued by an industrial development authority are paid solely from the revenue derived from the project and not from taxes. Wow. There is no lending of credit where revenue bonds issued by an industrial development are solely from the revenue derived from the project. Wow. And not from taxes. So there's lending a credit, I guess, when it comes from taxes. Well, this is interesting, but this takes us to a couple words now. We have sureties and we have bonds. So let's look at bonds here really quick to see when we talk about the revenue bonds and what the difference is from those in taxes. And the best place we could do that would definitely be from our friend here, Mr. Black. And let's find out what we mean here by the bonds in this context. So here a bond is an obligation or a promise An obligation, or in English, a bond, is a document written and sealed containing a confession of a debt. In later times, contract is the genus, obligation the species. Wow. The history of English law. All right. 2. A written promise to pay money or do some act if certain circumstances occur. So it's a written promise to do some act if certain circumstances occur or a certain time elapses. A promise that is defeasible upon a condition subsequent, especially an instrument under seal, by which 1. A public officer undertakes to pay a sum of money if he or she does not faithfully discharge the responsibilities of office, or 2. A surety undertakes that if the public officer does not do so, the surety will be liable in a penal sum. So that's pretty interesting. So under circumstances or a certain time, a written promise to pay, if, so it's a conditional, certain circumstances occur or certain time. So certain, specific, it's written, sealed. The fact that an instrument is called a bond is not conclusive as to its character. So it is necessary to disregard the nomenclature and look to the substance of the bond itself. The distinguishing feature of a bond is that it is an obligation to pay a fixed sum of money at a definite time with a stated interest, and it makes no difference whether a bond is designated by that name or some other, if it possesses the characteristics of a bond. There is no distinction between bonds and certificates of indebtedness which conform to all the characteristics of bonds. So, promise to pay within a certain amount of time, or if a certain circumstance occurs. Interesting there. So we have very many kinds of bonds, though. Blanket bond, a bond covering several persons or projects that require performance bonds. Fidelity bonds, blank bonds, archaic, bid bond. So lots of bonds, but we got that one down. But now it takes us to surety. We went over guarantee, but what's a surety? A surety, here we go, from the 14th century. It's a person. Remember, that could be a corporation, business, any type of entity like that is considered a person. It could be a natural person, but typically in this case, it's a person who is primarily liable for paying another's debt or performing another's obligation. Although a surety is similar to an insurer, one important difference is that a surety often receives no compensation for assuming liability. Why would they do it then? A surety differs from a guarantor, who is liable to the creditor only if the debtor does not meet the duties owed to the creditor. The surety is directly liable. So the words surety and guarantor are often used indiscriminately as synonymous terms. I already see the distinction here, though. But while a surety and a guarantor have this in common, they are both bound for another person, yet there are points of difference between them which should be carefully noted. A surety is usually bound with its principal by the same instrument, executed at the same time, and on the same consideration. So the surety knows the terms of the contract. It's time the contract sealed, the surety would be bound. He is an original promisor and the debtor from the beginning. So the same same parties here, and he is held ordinarily to know every default of this principle. Usually the surety will not be discharged either by the mere indulgence of the creditor to the principal or by want of notice of the default of the principal, no matter how much he may be injured thereby. On the other hand, the contract of the guarantor is his own separate undertaking, in which the principal does not join. So it's a separate contract here with your guarantor. It is usually entered into before or after that of the principal and is often founded on a separate consideration from that supporting the contract of the principal. A surety, in the broad sense, is one who is liable for the debt or obligation of another, whether primarily or secondarily, conditionally or unconditionally. In other words, the term surety includes anyone who is bound on an obligation which, as between himself and another person who is bound to the obligee for the same performance, the latter, obligor, should discharge. In this sense, the suretyship includes all accessoral obligations. By such terminology, guarantors and endorsers are kinds of sureties. A surety in the narrow sense is one who is liable in form primarily on the debt or obligation of another. His obligation is accessorial to that of the principal debtor, but is direct and not conditioned on the principal debtor's default. Okay, so there's a difference. His obligation is not conditioned. It's direct but not conditioned on the principal's debtor's default. In this sense, the suretyship differs from guarantee and endorsement, which are conditional. Secondary obligations. The word surety is in the majority of American decisions used in the narrower sense to indicate a primary obligation to pay another's debt, to distinguish it from the secondary obligation of a guarantor. This terminology has the advantage of indicating, by the use of one word, surety, an obligation which is at once to pay another's debt, but which at the same time is not conditioned upon another's default. So there it is. The surety is something where it's a guarantee basically from the start and can't be discharged. I think is the big difference here. And it's unconditional in the narrowest sense. All right. And I think we have all kinds of sureties here. Voluntary surety, surety bond, performance bond, all these great things here. Real suretyship, a suretyship in which specified property can be taken, but the surety is not answerable in damages. Wow. There's suretyship by operation of law, a suretyship that the law creates when third party promises a debtor to assume and pay the debt that the debtor owes to the creditor. When the law creates, wow, now that's going to be some interesting stuff there. All right, enough of that with the sureties and the bonds. Let's get back to the presentation.
Paro 3766 says, vital records is the revenue resource origin. Just saying the origin of suretyship.
Yep, so indeed. But as we speak here, we're speaking about public funds here. So the suretyship is what we're looking at here, and just this one, we're just actually looking at here in the definition, the suretyship here. So some courts have construed a credit clause as proscribing only suretyship or loan guarantee arrangements without affecting the borrowing by the state as primary debtor. So credit clause. This is the narrow construction of credit clauses. And there is no lending of credit where revenue bonds issued by an industrial development authority are paid solely from the revenue derived from the project and not taxes. So when they're doing the bonds like that, But again, the taxes, that's an interesting case to find out here. Why taxes and not the bonds, revenue bonds issued, paid solely from the revenue derived from the lending of the credit. Okay, let's look at the transfer of funds. Whether there is an unlawful diversion by a transfer of money from one public fund to another depends to a large extent upon the statutory provisions and constitutional limitations. So there we go. Statutory provisions typically is what they're looking at. And of course, there's the constitutional limitations. The public revenue in the state treasury is under the plenary control of the legislature and is subject to constitutionally enacted laws. That's in the state treasury. But public revenue derived from taxation and lawfully allocated to a special fund or appropriated for any purpose cannot be administratively or by legislative resolution diverted or taken therefrom. Now that's interesting there. So the state treasury is under the plenary control of the legislature, but it seems like public revenue derived from taxation lawfully allocated to a special fund, not your general funds here, or appropriated for any purpose, cannot be administratively or by legislative resolution diverted or taken therefrom. So by transferring to these special funds or appropriation funds, when a special fund is raised for a particular purpose under legislative authority or by special tax or bond issue or the like, or money is appropriated for a specified purpose, it cannot be used for any other purpose, either permanently or temporarily, until the purpose for which it is intended has been fully accomplished. So this explains more of that case. It seemed confusing. But when there's a bond issue, it's to raise money for a particular purpose, aside from paying back, the project. But in that case, it seems that it can't be diverted and used for other purposes, invested or risked in any other ways. It can only be used what it was originally allocated for in the bonds. And when funds are raised by the issuance of bonds for a designated purpose, they cannot be diverted to some other purpose. The proceeds of a bond issue are sometimes held to be in the nature of a trust fund. There it is. Now it's even more clear. Let's move along. The bond revenue protection. Revenues pledged to preserve and protect the security of outstanding bonds may not be diverted or transferred for general use. Now, our general rule is the interest earned on public funds designated for a specific purpose follows those funds. So the interest stays with those funds. You can't be diverting that interest. The exception, though, is in some jurisdictions, earnings from the deposit or investment of those appropriated funds may be statutorily directed to the state's general fund. Okay. Where it would be under the control of the legislature there. Then we have the temporary transfers between funds. This sounds pretty fishy. The question of the right of a county or municipality temporarily to loan or transfer money from one fund or department to another cannot be completely answered by resort to authorities denying or sustaining the right to make such a loan or transfer. Some of the cases have been decided upon statutes expressly conferring to the right to transfer funds, rather than upon general principles of law. The right to borrow money temporarily from one fund for use in another has been sustained in some cases and denied in others. So, if you're friends with the judge, you could probably divert your funds. All right, now we get to deposits in general. This is a very interesting part here. A legislature has the power to provide for the safety of public funds. So there's a legislative authority. Ordinarily, the right to power and duty to deposit funds, as well as the location of the depository and the manner, nature, time, and amount of deposits, are regulated by statute. Public funds should be deposited in accordance therewith. Well, who makes sure of that? Boards and officials in control of public funds are governed by strict regulations regarding depositories and deposits of such funds therein or in banks other than designated depositories. And they are generally without power to deviate from the letter of such governing statutes. However, where it is manifest to the court either that strict compliance with the letter of the law as to contracts for the deposit of public funds is impossible, or that the purpose of governing statute can be best served by a departure from the literal requirements as to such contracts, it has been held that the board or official has a power to enter into contracts which are in conformity with the spirit, although not the letter, of the law. Oh, wow. So there's how they get around it, to contract. Conformity with the spirit, although not the letter. Now those are some terms of art there, huh? Let's move along. Those would be some interesting cases to look at. But we're just going through the body of the American jurisprudence here. Let's move along with the nature of deposits and the ownership of these funds. There's a general versus special deposit. The general deposit transfers title to the bank. The bank owes a debt to repay, like any checking account. A special deposit keeps the depositor's ownership intact. Wow, so like the bank holds specific funds in trust, like a safe deposit box for cash. Wow. Statutes may regulate the type of deposits which can or must be used for public funds, and under some statutes, only general deposits are authorized. It seems so, it should be. Courts have usually viewed the deposit of public funds in the same light as the deposit of non-public funds insofar as their general or special nature is concerned. Thus, a deposit of public funds does not, by virtue of the fact that the funds are public, become a special deposit. Whether a deposit is or is not a special deposit will depend upon the agreement and understanding of the parties, at least in absence of legislation limiting the right of the public officers to make general deposits of public funds. The agreement and understanding. So there's your contracts here, right? Agreement, understanding. You'd have that mutual assent. All right. Debtor-creditor relationship. When a general deposit of public money is lawfully made, that's going into the general. This is where transfers title to the bank. So the bank owes, this is just accounting here. When you say the bank owes a debt to repay, that's what a deposit gets you there. When a general deposit, though, of public money is lawfully made, the title to the money passes to the depository, in this case the bank here. The relationship between the depository and the depositor is that of debtor and creditor. So there it is. Let's look at the nature of deposits here further. There's lawful general deposit, which is a deposit of public funds left with it under a general deposit. And that's not going to be a trustee. Remember, title passes to the depository bank. Public funds are deposited specially as the funds of the state. They remain the property of the state. Now that can be confusing there. Wrongful or unlawful deposit. If the deposit is wrongful or unlawful, the depository acquires no title thereto, but holds the deposit in trust for the true owner. So it becomes, I guess, by default there, a special deposit. So here's a special deposit by operation law. Sometimes by operation law, a deposit of funds by a public treasurer. Wait a second here. A deposit of funds by a public treasurer in a bank creates a contract of special deposit, as where there is no lawful way for the funds to reach the depository other than upon special deposit. Wow. Deposit of funds by a public treasurer in a bank creates a contract of a special deposit. Sometimes. Those would be some interesting laws to look at. Now we see the deposit as a loan or investment. Why this distinction matters. If a bank deposit is classified as a loan or investment, it may violate constitutional or statutory prohibitions against lending public credit. The classification determines legality. Now we're talking about public credit here. Majority view, deposit is not a loan. Notwithstanding the fact that an authorized deposit of public funds creates the relation of debtor and creditor, some courts have held that the authorized placing of public funds in a general deposit for safekeeping does not constitute a loan within the meaning of the constitutional or statutory prohibitions against lending public credit, even though the bank agrees to pay interest on daily balances if the deposit is a demand deposit without time limit or other conditions as to payment, and the deposit is made in the usual course of business for the sake of convenience and not for the purpose of aiding the bank. Convenience. Then we have a minority view, though the deposit's a loan. However, it has sometimes been held that such a deposit constitutes a loan to the bank or an investment of the money deposited in violation of a statute forbidding public officers to lend the funds in their hands. So where do you deposit? All right. As you can see here, as public funds accumulate, There's lots of opportunities to do many different things with it because not too many people can notice where all this is going. So salute to those of you that are here as we learn about this a little bit deeper here. The prevailing view is that the deposits of funds in a bank not generally considered an investment in violation of constitutional prohibition. As we say here, it's a creditor-debtor relationship, but not necessarily of credit, extending credit like that. The early contrary authority. There is some early authority supporting the view that an interest-bearing general deposit of public funds in a bank constitutes an investment within the terms of a constitutional provision or statute. Whew. Then we have savings and loan associations and the stock purchase question here. So it's not a stock purchase. Some cases hold that the deposit of public funds in a savings and loan association does not constitute a purchase of stock in a private corporation in violation of a constitutional prohibition against the giving of money or property or the loaning of money or credit to or in aid of any individual, association, or corporation. There's contrary holdings, so other courts hold to the contrary, finding that such a deposit does constitute a prohibited purchase of stock or lending of credit. So savings and loan associations. All right. As you can see here, everyone's fighting about where the money belongs. So let's look further here with these depositories now. And if you haven't already, please do hit the like, and I believe we do still have the talking chat enabled.
The tribe says, hit the like.
Indeed we do. All right, let's proceed. So what's a depository? A depository of public funds has been defined as a person, real or artificial, designated by law, with whom public officials may or shall leave public funds for safekeeping. The depository, a person, where we leave funds for safekeeping. View 1, the contractee. According to some authorities, a depository is a contractee, not a public officer. So the government contracts with the depository. But there's a second view here, the quasi-public official. Another view is that public depository is a quasi-public official whose bond is an official bond. Wow. What we saw here with the bond is that promise to hold up, and now they have an official bond. The depositor's guarantee fund. Banks may be required by statute to contribute to a depositor's guarantee fund. Wow, the banks may be required by statute to contribute to the guarantee fund to be used to pay depositors should the bank fail. Guarantee fund. So who holds the guarantee fund? Legislation providing for the creation of funds for the purpose of preventing or equalizing the loss of public funds deposited according to law in a depository has been held to be valid against various constitutional objections. Wow. So I see. As if you have to worry. Why would the state be depositing it in worrisome banks, you'd think? But when we're talking about this amount of money that the states collect for public funds, you can see where the greediness really steps in here. We're looking at a scale that they can't even publicly talk about. It's embarrassing. All right, let's look at the duties here. No obligation to hold specific cash. A depository of public funds is not required to keep on hand the actual money placed in a general deposit or an amount in cash equal thereto. Money deposited in a bank by a county to the credit of a special fund is, so far as the depository bank is concerned, a general deposit which the bank has the right to mingle with other monies, and it is not bound to keep in return the specific money received. However, it is the duty of a depository of public funds to account for and pay the deposit on demand to the person entitled thereto. Rendering a statement of funds on hand is not an accounting for or a paying over of the funds. To constitute payment, The money must pass from the depository to the public officer for the purposes of extinguishing the debt, and unless there is such a payment, neither the depository nor its sureties are relieved from liability. So here we go. Understand this, is that when you put money into an account, then you become the creditor and the bank is the debtor for there. So when they it seems that they can do what they do with anyone's money, even with public funds, because that's the nature of banks, to commingle the monies. And it's not bound to keep and return the specific money received, which is very interesting sounding, because what specific money? If I loan you $20 and you pay me back $20, it's a different $20 bill. Did you pay me back the same specific money? So this is kind of interesting here. We say specific money. Again, these are terms of art here when it gets down to this. And to really look into this, we'd probably have to look at the cases, but we don't have time for that tonight. We're going to move along. That would be for homework if you decide to do such. And by the way, you stay to the end. There will be a very special treat at the end of this presentation, so definitely want to stay tuned. So let's look at the payment of interest now. This is the stickler issue. When we're talking about these huge funds, there's a lot of interest sitting on the table here for the depository to pay out to the public body or whichever is depositing these public funds. A lot of temptation. The default rule here is the depository is not liable for the payment of interest in the absence of a provision therefor in a statute or contract of deposit. In practice, though, statutes and depository agreements usually require that interest be paid, but how many people get paid interest today anyways? Of course, with these amounts of money, you better believe they get some interest. Now, terminating or reducing interest rates. The right to terminate the payment of interest on deposits or to reduce the interest rate depends upon several factors. Statutory and charter provisions, as well as a contract between the public officer making the deposit and the depository, must be considered. If the depository relation is not for any fixed term, and the statute does not prohibit, the depository may, by notice to the depositor, reduce the interest rate or terminate the payment of interest on deposited funds. Let's see here. Statute does not prohibit. It is then optional with the depositor to withdraw its deposit or to continue at the reduced interest rate or without interest, as the case may be. So you could just say, take your money and go. I guess is this polite way of saying it. Was that we're not going to pay you interest. Acceptance by city officers of a reduction of the interest rate on deposits of city funds is affected by the continuation of the deposits after notice from the bank of the reduction and the acceptance without protest or objection of the monthly payment of interest at the reduced rates. Acceptance by the city officers of a reduction. So that's pretty interesting there. What you would think you're getting a rate and it gets reduced or the interest terminates. A lot of fishy stuff goes on with public funds, but that's why we're doing this. A lot of this has to do with accounting, but if you want to hold them accountable, you need to know some accounting. And that's what we're doing here, so let's continue with the payment of interest. Here's our supplement case. The term effective cost of funds. Effective cost of funds. In interest rate provision of a job development authority loan agreement was unambiguous and included interest. The JDA had to pay to bondholders, cost of issuing the bond, and the cost of defaults by borrowers who received loans from bond proceeds. Wow. The cost of defaults. Loss engendered by defaulting borrowers was a readily perceivable risk for any lender which the JDA was entitled to consider in calculating interest rate charged to the borrower. Wow, it's a job development authority loaning money. Oh, okay, I see. So they're loaning out money and then borrowers default, but they did bonds to build the Wow, gosh, what state is this? Okay, New York. That was 2002. So the context here is the Job Development Authority is a public body that issues bonds and uses the proceeds to make loans to businesses. This case addresses how the JDA calculates the interest rate it charges borrowers, including the cost of bond defaults by other borrowers. Cost of issuing the bond, cost of defaults, and what they had to pay bondholders. Interesting. So it's a scheme. I get it. They're all schemes with these public funds because, how many people are studying this like we are right now to even be aware of all these little schemes that could go on and seemingly totally legal. Here's selection or designation. In some jurisdictions, limitations on the designation of a depository for public funds have been imposed by the Constitution. More commonly, however, the designation of a depository for public funds is regulated by statute. So check your jurisdiction. In the absence of express statutory authority to designate a public depository, the power to do so may be implied from other powers granted. So the public officer gets to decide his favorite bank. Maybe he even owes the bank president. But of course, that would be full disclosure, right? In general, statutory requirements, including who is to make the designation, how the depository is to be chosen, and who is qualified to act as depository, are construed literally. Where a statute prescribes the qualifications of depositories and that the banks having such qualifications shall be selected impartially, an officer or other department of the government cannot reject any bank presenting itself with such qualifications. And there's a mandamus remedy, though. A duly selected, so done properly through law, and qualified depository may, by mandamus, force the deposit with its share of public funds. Wow. That's interesting. Duly selected. Okay. Now we're on to the selection here with the spirit versus the letter of the law, as we saw before. So let's really dig in deep into the nuances here, as they would say. Substantial compliance doctrine. Compliance with provisions for the selection and designation of depositories need not always be literal. Compliance with the spirit of the provisions is sometimes deemed to be sufficient, where a deviation from the letter of the law is justified by the necessities of the occasion. Convenience. The short term permitted. So a statute providing that depositories for the county fund shall be designated for the term for which the county treasurer is elected does not preclude designation for a shorter period, where the depository, otherwise qualified to receive a deposit of public funds, cannot, in view of limitations imposed by statute upon its powers, enter into a contract to pay interest on a deposit of public funds for a period such as length term of the treasurer. Whew. So short terms permitted, but the early designation is allowed too, under a statute providing that a board or official shall designate depositories at special times. The board or official may select a depository as soon as the law goes into effect, where the first time such designation according to the statute is some months hence, and where it is evident that the intention of the legislature that the law should be immediately effective. So you can definitely have the laws set up so that if it's immediately effective, you can get that early designation of of the depositories here. The interest rate-based selection here now. Now, as we saw before, they could lower the interest rate or just eliminate it as long as the public official agrees. But we have a statute may require that an otherwise qualified depository which offers the highest of interest or which offers the highest rate of interest consistent with the safety of the funds may be designated. Okay, consistent with the safety. So there's risk associated with too high of an interest rate. I get it. But playing games with public funds is never a good gamble. But I digress. All right, let's look at the location of the depository. So the jurisdictional requirements. The statutes frequently name the jurisdiction within which a depository of public funds shall be located, and under varying circumstances, courts have either upheld or rejected the designation of a depository which is located outside the specified jurisdiction. Well, I could see why you'd want it in your jurisdiction. Courts have upheld the designations of depositories located outside the specified jurisdictions when circumstances warranted flexibility. Rejected. Other courts have rejected out of jurisdiction designations as exceeding statutory authority. Now, that's more in line with what I would imagine. But as you see here, depending on your jurisdiction, it can be quite different. And I bet there's a pattern to where you'll see more corruption in one of those two. All right. Let's see here for the security for the deposit. As we saw in here, that collateral promise here for the deposits, the security types, the bond requirements, and the surety liability. As we saw before, the surety can't be discharged. So we have different security types here in general. There's pledged assets. This is key here. In some jurisdictions, the depository may pledge assets in order to provide security for public funds deposited with it. There's a bond required in some jurisdictions, and still others, the depository may be required to provide either collateral security or a bond. So we want some confidence that we're depositing these public funds, that there's either going to be some kind of assets that are pledged for security or a bond. The federal statute here with national banks, in order to enable national banks to compete with state banks on equal terms for the deposits of states, cities, and the like, a federal statute expressly provides that any national banking association may give security for the safekeeping and prompt payment of any funds of any state or political subdivision or any agency or other governmental instrumentality of one or more states or political subdivisions which are deposited with it, including deposits by officers, employees, or agents in their official capacity to the same extent and of the same kind as is authorized for other banking institutions by law of the state in which the National Banking Association is located. So they still have to be located, but in that state. But I kind of like it more when they're in the jurisdiction. It's not a national bank here, but what do I know? Okay, so increasing or substituting security. Oh boy. Inherent authority to maintain security. Power of state officers to obtain good and ample security for a deposit. So remember, there's backing by assets here of state funds carries with it authority to maintain it by approving more security for deposits already made and to permit the substitution of security. Wow. So there's pre-deposit approval is not a bar. The fact that statute requires that the security be approved before the funds are deposited does not preclude the taking of more or substitute security for funds already deposited. Huh. Or substitute security for funds. Wow, that doesn't sound right. There's constructive redeposit. The presentation of approval of such security is treated as the equivalent of a withdrawal and redeposit of the public funds, a legal fiction that validates the new security. So withdrawal and redeposit, constructive redeposit. Boy, why this matters. Without the rule, if a surety's financial condition weakened after a deposit was made, the state would have no way to require additional security, potentially leaving public funds unprotected. Okay. The surety's financial condition. Wow. Okay. Why is this starting to sound like a house of cards here with our public funds? All right, bonds generally. The depository bond explained. A depository bond is a guarantee backed by a surety. So now we're looking in the narrower sense. It's not just a guarantee. It's a guarantee backed by a surety that the bank will safely keep and return public funds. If the bank fails, the surety must pay. So it's a separate contract, but it still incorporates a surety. Statutory provisions in many jurisdictions require depositories of public funds to give bond in an amount sufficient to secure the safety of the deposits. Secure the safety of the deposits. A bond in the amount sufficient to secure. However, it is sometimes said that rigid compliance with all the minutiae of the statute is not indispensable to the validity of a depository bond. Substantial compliance is sufficient. We see this a lot. Substantial. Well, why did they write the statute? Who needs to write minutiae if it's just substantial compliance? Well, let's look at it in practice. Substantial compliance with a statute requiring depository bonds to be made to the county has been found where the bond given ran to the treasurer for the county. A bond conditioned on faithful performance by the bank of all duties instead of upon the safety of the deposit has been deemed sufficient. Oh gosh. Similarly, a bond containing a provision to account for the funds deposited together with a special rate of interest has been held not invalid on the ground that it is more onerous than the state requires. Special has not been held invalid. Okay. Oh boy. So the substantial compliance, again, this is something where terms of art, so to speak, come into play. Conditions contained in a bond which have the same legal effect as those prescribed by a statute are sufficient. So the bond contains wording it should mirror the statute. The obligation of a bond is binding, even though public funds are deposited in the bank after the bond is executed, but before the designation is made, if the bank subsequently designated as an official depository. Before the designation is made. So, wow, that's kind of interesting there. The obligation of the bond is binding. You'd think that the bond starts when it's executed. The bank, the deposit of the bank after the bond is executed. So you've executed the bond before depositing the funds. Well, I guess, yeah, you'd have the agreement with the depository set. And you don't deposit funds yet, but you'd have the bond set up in anticipation of the funds. If the statute requiring a bond does not fix the payee, a bond running to the state is sufficient. Even if the depository bond does not comply strictly with the statute, there is authority that it may be enforced as a common law bond. Wow. So here's our supplement case. Now, before we do that, let's see what we mean here by a common law bond, because I think that's something that's under our bonds here that we were looking at before. We didn't look at the common law bond. Let's look at the common law bond here. So we have bonds, appeal bond, common law bond. Here it is. It's a performance bond given by a construction contractor. A common law bond exceeds the requirements of a statutory performance bond because it provides additional coverage for construction projects. Wow. For construction projects. Okay, so that was, who would have known? All right. Well, how they worked that one in there, but even if a depository bond does not comply strictly with the statute, there is an authority that it may be enforced as a common law bond. That's for construction, but I guess be enforced as a common law bond. But see Cool versus Chamberlain in Iowa, in which the court refused to construe a bond requiring that a bank account to the proper authority for money coming into its hands as a public depository as establishing any common law liability of the surety in favor of a county treasurer who had deposited the funds in the bank, notwithstanding that the bank had not been duly appointed as a depository and was compelled to account for the funds after the bank failed. Wow. See, court refused to construe a bond requiring the bank account to the proper authority for the money. Wow. Okay, let's look at approval, construction, and statute. This moves quickly here because we're getting closer to the end. The bond approval. The approval of the bond by a depository by a public officer group committee is generally required by statute before funds are deposited. Such statutes are made for the protection of such funds and not for the benefit of the sureties. And a surety who executes and delivers a bond upon the faith of which public funds are delivered to his or her principal cannot defend against liability on the bond on the ground that it has never been approved. So bond approval, upon approval, required by statute before there it is. So the approval of the bond and cannot defend against liability on a bond on the ground it has never been approved. There it is. So the construction of bond liability. A depository bond as a whole and every part of it must be looked to in arriving at the intention of the parties. The rule that the obligation of a surety is to be strictly construed applicable in the case of uncompensated sureties, may not be invoked as the officers and stockholders of a bank who, for the purpose of securing a deposit therein, have become sureties on the bank's depository bond. Goodness. And the effect of statute on a bond. The statute providing for giving of a bond by a depository becomes part of the bond. Wow, so the statute providing for the giving of a bond by a depository becomes part of the bond. So the statute has to be incorporated into the bond or mirrored in there. Unauthorized provisions will be read out of it, and necessary matter not expressed read into it and given effect. Provisions which limit or restrict statutory liability may be treated as surplusage, and omitted statutory obligations may be supplied and read into the bond. Wow. So the effects of the statute on the bond is that they can be read into, or things can be restricted or read out of. So there it is. Statutes have a lot of saying on those bonds, depending on your jurisdiction. And here's our factors determining the coverage. The liability of a surety on a bond to secure the deposit of public funds at a bank may be dependent upon 1, whether the particular money is in fact public money. So the liability of the surety depends on this. Or 2, the particular purposes for which the funds are being held. So particular money is in fact public money. So that gets to be confusing. It's the interest, public money, and all these other issues that come up with a surety. And 2, the particular purposes for which the funds are being held. So that's going to determine the coverage of the surety. And 3, their source. And 4, the form of transaction. A deposit of public funds upon a time certificate has been deemed to be within the protection of the bond given by the depository bank, although there is some authority to the contrary. Then we have deposits before or after the bond execution, as we read earlier. Whether a surety on a deposit bond is liable for deposits which were made before the bond was executed will depend upon the terms of the bond, construed in light of the circumstances of its execution. In the absence of explanatory circumstances, the surety is not liable for money deposited before the bond was executed, where the bond clearly refers to the deposit to be made in the future. Yet, where terms indicate coverage of prior deposits, courts have held sureties liable. Well, that's kind of interesting to have post-dated sureties, but when the term of a depository's bond are ambiguous as to the deposits covered in it, the sureties are liable for deposits made prior to the execution of the bond. So, ambiguous. Certain acts of the parties have sometimes been viewed as amounting to a redeposit. After the execution of the bond. Okay, so another way to do it. I understand this because the timing of everything would be covered by that particular bond of money actually on deposit prior to its execution, thus bringing such an amount within the protection of the bond. So you take it out, you put it back in. Can you believe this stuff is this is required by law? All right. With our public funds, I can understand if this was all private stuff, but boy, the surety's liability here. The surety as insurer, the obligation of the surety on a bond given by a bank as a depository of public funds is that of an insurer. So Again, the surety isn't usually conditional, but an insurer is. A surety has sometimes been held liable for the full amount of the deposit, not merely for the amount on the bond, on the theory that the bond showed the parties compensated deposits at times would exceed the bond amount. Okay. So the bonds for a certain amount, but the contemplated deposits would exceed the bond amount. At least one court has held that a pro rata clause stipulating that the surety shall be liable only for its proportional share of the total loss is not void as inconsistent with the statute, but where a statute expressly provides that the original bond shall not be discharged when an additional bond is given. A pro rata clause in the depository bond is in conflict with the statute and is treated as surplusage. Nice, double dipping. Where successive bonds have been given, sureties on the earlier bond are liable for the amount on deposit at the time of the latter bond, or the later bond, less payments subsequently made. However, they are entitled to be indemnified by sureties on an earlier bond for prior deposits that were required to make good. Okay, so a lot of catching up there. Let's look at the duration and termination of liability. So a surety's liability on the bonded deposit of a depository of public funds may be terminated by the expiration or cancellation of the bond or by the giving or substitution of another bond. Okay, so usually you're not seeing substitutions with sureties, but I guess it's depends here. Well, it's substitution of another bond. Okay, where the obligation is that the depository shall faithfully account for and pay over all monies deposited during a certain period. Liability on the bond for such deposits continues after the expiration date of the bond. And where the statute provides that the bond shall cover only one term. The bond expires with the term of the county treasurer and does not apply to funds deposited by his or her successor, even though the bond runs for a period beyond the term of the outgoing treasurer. Okay, so the public official, it's not necessarily his term. Oh, wait a second. No, it does. Okay, so where the statute provides. Okay, when the statute provides. So again, those statutory terms can override the bond. The bond doesn't even have to say that. But when the treasurer changes, now the treasurer has to go get a new bond, I guess, the new successor. Incredible. However, in some circumstances, courts have held that a bond covers deposits made during a subsequent term of office of the official making the deposit. I mean, just a trustee, right? They're custodians. A statute providing that every bank designated as a state depository shall renew its bond every 4 years does not operate to terminate at the end of 4 years bonds which contain no time limit. Okay, so again, the statutes basically run that whole show. We have cancellation, discharge, surety. The bond may be terminated by a cancellation provision in the bond by giving reasonable notice even without a cancellation clause where the bond has no definite time to run, or by substitution of another bond. A surety upon a bond running for no definite time may be discharged from liability by the state's failure to comply with the surety's demand that it withdraw or sue for deposit within a limited time, so far as deposits made after such demand are concerned. However, liability of a surety is not discharged as the checks outstanding at the time the bank was closed by delay in presenting them for payment sufficient to discharge the drawer from liability to the payee. So, just being late cashing the checks doesn't remove liability or discharge liability of the surety. So the sureties are not released by deposit changes. The sureties on the bond of a county depository are not released by the attempt of the county to change interest-bearing deposit into an unsecured non-interest-bearing deposit, because the surety's guarantee is not of any contract between the city and depository, but only exists in conduct of the depository. Wow. The surety on a depository bond is not released by making deposits in excess of the limitation amount to be deposited contained in the bond. Oh boy. Very interesting here. Then we have the joint action required for release. If state requires that several named officials approve the security for public funds, only those officers acting together may release the security. The state is not stopped from denying the authority of a state treasurer acting alone to consent to the cancellation of a depository bond. Man. So then there's the constitutional validity of surety relief statutes. Statutes relieving sureties of depositories from liability have been held constitutional in some, but not all cases. A statute releasing uncompensated securities has been upheld against contentions that it constituted class legislation. Violated due process of law and impaired contract obligations. So there's some good ones there. But see Schennebeck versus McCrary, in which the United States Supreme Court, in affirming a state court decision holding that there was no impairment of contract rights resulting from a statute releasing bondsmen of a depository where the funds have been lost through insolvency of the depository, refused to examine the alleged contract, stating that it saw no reason to disturb the state court's ruling that, unlike the situation involving persons having vested rights in an improvement district, the taxpayers had no vested interest in general public funds. You gotta be kidding. Well, there it is. All right, come on. Trying to get to the next slide. There we go. Insolvency and reorganization. Surety is liable. According to one view, the surety is liable. The contract contemplated inability to pay on demand, and a demand is lawful, even though unavailing because the bank is in the hands of a conservator. The default of the bank is a contemplated risk. Gosh, there is no impossibility of performance. Well, the surety is not liable here. There is authority that the surety company is not liable when the conservator has been appointed and payments suspended by operation of law, notwithstanding that at the time of suit the bank had made no successful effort to reopen for business. Wow. And then we have the novation, the merger and consolidation. So to renew the contract here, mergers and consolidations, the principle that the novation of a contract which is guaranteed by surety will discharge a surety from his or her obligation has been asserted successfully in some cases, but unsuccessfully in others, with reference to the liability of the surety or guarantor of a bank deposit after merger, consolidation, or reorganization. Well, I can see it. It has been held that the liability of sureties on a bond given by a bank as a depository of county funds does not extend to deposits made by the county treasurer in a bank to which assets and liabilities of the depository bank have been transferred upon a merger, although the new bank occupies the same place as the business. Such liability is discharged where unallocated withdrawals equal the amount on deposit at the time of the merger. Unallocated withdrawals equal the amount on deposit. Well, that's interesting. So I guess if you liquidate the account, then I guess the surety is discharged, right? Let's move to the next one here. Now we get the irregularities in designation. The sureties on an official bond given by a designated depository which receives and holds public funds will not be relieved from liability because of the invalidity of the designation of the depository. So once they're designated, the surety won't be relieved from liability. And then there's the invalid deposit. Since the main reason for requiring a bond is to guard against possible defaults, a surety is generally not excused from its obligation by reason of improper action on the part of the depositing officer or the depository. The depositor's bond covers the deposit even if the deposit constitutes an unauthorized loan. So again, your unauthorized loan, you're depositing money. It's might be a loan. You're the creditor. All right. Majority rule on excess deposits. It's been recognized that the fact that the official making deposits has failed to limit them to the amount authorized by statute is no reason for absolving the sureties from liability for such part of the deposits as within the statutory limitation. It's far more frequently held that the sureties on a public depository bond are liable up to the full penalty named in the bond without regard to whether the deposits exceed the statutory limitation. So again, we keep seeing this theme that bonds are liable to the full penalty named in the bond, and that's without regard to the deposits exceeding the statutory limitation. So the bond could be higher than the statutory limitation, and deposits might go above statutory limitation. The bond would still be liable, looks like here, for the excess deposits. The statute was not enacted for the purpose of limiting the liability of the sureties on the depository bond, but only as an additional safeguard against the loss of funds deposited. A lot of work for failing banks. It seems like, geez, could there be a better way? Now we get the enforcement and the penalties, and where a breach of bond occurs, the obligation of the surety may be enforced by appropriate action. One or more distinct breaches may be alleged. So breach of bond, obligation of the surety may be enforced. The state or its subdivision as plaintiff is entitled to maintain a single suit in equity to which all the sureties on a bond are parties in order that complete relief may be granted. The county sued to establish its claim against an insolvent depository as one which should be paid out of the state bank depositor's guarantee fund does not constitute an election of remedies which will preclude it from maintaining a suit against the sureties on the depository's bond for the rest of its money. Man, a lot of difficulties it seems here for something as simple as just depositing public funds, huh? A lot of work. Penalties and attorney's fees. The legislature may make a depository of county funds of it liable for the penalty for delay in returning funds deposited, as well as for counsel fees for service and compelling payment. Although a surety on the bond will accept such liability to the extent of the bond, damages and counsel fees cannot be assessed against the surety in excess of the penalty of the bond. So up to the limits here, right? They'll get it under a statute rendering the depository liable for such charges. So they're liable for that, but only up to the amount of the bond. All right, now let's look at the federal depositories, and this will be wrapping up really soon now. So salute to you that have stayed this long. We're about to get to the best part too. So let's continue. The congressional rationale. Congress is recognized as more efficient for the Treasury to act through national banks in fulfilling its statutory mandate of managing the nation's money than it is for the federal government alone to develop and maintain a banking system. The power to designate depositories of money is vested in the Secretary of the Treasury. If necessary to carry out the business of the federal government, the Secretary may designate depositories in federal counties and in the United States territories and possessions to receive deposits of public money. And the Secretary may transfer public money in the possession of a depository to the Treasury, or if the Secretary believes the safety of public money and convenience requires it, to another depository. Here's our observation. The designation of a depository is not subject to procurement regulations. So yeah, they get a lot of leeway here. Amounts to which are received by the federal government as trustee, other than amounts received by the Comptroller of the Currency and the Federal Deposit Insurance Corporation, are deposited in appropriate trust funds in the Treasury. That's where the big money's going there. When commercial national banks act as depositories, they do so as special agents. So they're like trustees, huh? Public policy demands that every depository of public money should be held to strict accountability. Depositories of public money are subject to audit by the Secretary or the Secretary's designated officer, employee, or agent. And there's a federal criminal liability. The failure of the Treasurer of the United States or any public depository to keep safely any federal monies deposited by a dispersing officer or agent or receiver, collector, or other person constitutes embezzlement and subjects the depository to fine or imprisonment or both. The failure to keep safely any federal monies deposited is embezzlement. Observation: the standards for proving guilt under the statute are less exacting than those generally applicable in cases of conventional embezzlement. So it looks like it's held to a very high standard. Definitely don't want to be abusing that federal public funds. And there's particular institutions, Federal Reserve banks, national banking institutions. So the federal statute provides that revenues of the federal government may be deposited in Federal Reserve banks. Now we know Federal Reserve banks are not the federal government. I love how they slap it around like this here. Federal government with a capital F and Federal Reserve banks. And that monies held in the general fund of the Treasury may, upon direction of the Secretary of the Treasury, be deposited in Federal Reserve banks. No government funds or postal savings may be deposited in any bank not belonging to the Federal Reserve System. And yeah, there's the postal savings. They have their whole little banking system here. So as you see here, the postal savings can only be deposited in the Federal Reserve System. Then there's national banking associations. All national banking associations designated by the Secretary of the Treasury shall be depositories of public money. Under such regulations as may be prescribed by the Secretary, must perform all reasonable duties required. Every national banking association designed as receiver or depository of public money is required to take and receive at par all the national currency bills by whatever association issued, which have been paid into the government for internal revenue or for loans or stocks. Observation: the Secretary is directed by statute to distribute deposits as far as practicable equitably between the different states and sections. Of course, that would all be through the Federal Reserve System, I'm sure. The security requirements for the national banking associations. The National Banking Association designated as a depository of public money is required by federal statute to give satisfactory security by the deposit of the United States bonds or otherwise for the safekeeping and prompt payment of the public money deposited with it, and for the faithful performance of its duties as financial agent of the government. Now we have state banks and insured deposits. State member banks and trust companies. All state banks and trust companies which are members of the Federal Reserve System may be designated as depositories upon the furnishing of satisfactory security, subject to the regulations. Okay, we know. And then the FDIC insured banks under the Federal Reserve Act. The Federal Reserve Act provides that the Secretary of Treasury may designate any bank the deposits of which are insured by the Federal Deposit Insurance Corporation and depository of public money of the United States upon giving of satisfactory security. Security is not required for the safekeeping and prompt payment of such parts of the deposits of public money or as insured deposits. Each officer, employee, or agent of the United States having official custody of public funds and lawfully depositing public funds in an insured bank for the purpose of determining the amount of insured deposits deemed a depositor in custodial capacity, separate and distinct from any other officer, employee, or agent. Whew. And here's our observation. There can be no discrimination against or preference for national banking institutions, state banks, which are members of the Federal Reserve, or insured banks that are not members of the Federal Reserve by class, and those enjoying benefits directly or indirectly or disbursed public funds cannot so discriminate or show preference. So we saw before where they could be compelled to take deposits. Strange. and other federal depositories. You have the state-insured institutions, ones designated by agencies as depositories, and secretaries, regulatory designation of depositories. So we have the National Credit Union. I'm not going to read all these here because these are just listing a lot of the different ways. Other federal depositories, because they can use state-insured institutions, and they can designate, the Secretary of Treasury can, different depositories, and also the regulatory designations. And our supplement from here with the UCC, 12 U.S.C. Section 90, adding that 1. The Secretary must annually, by a date set forth in statute, make a public statement of the securities required during that year for such deposits. Wow. So that must be a public statement. We can find that one. And 2, if the funds of any federally recognized Indian tribe are deposited with the National Banking Association or association's officer, employee, or agent, the banking association may give security for the safekeeping and prompt payment of the deposited funds by depositing United States bonds or otherwise, as prescribed by the Secretary of the Treasury. And we also have 12 U.S.C. Section 265, adding that the public money of the United States is deemed to include, without being limited to thereto, revenues and funds of the United States, and any funds of the deposit of which subject to the control and regulation of the United States or any of its officers, agents, employees, and the Postal Savings Fund. Can't forget about that. And depositories for particular purposes, the Internal Revenue and Tobacco Tax depositories. So the Secretary of Treasury can authorize Federal Reserve and incorporated banks, trusts, domestic building and loan associations to receive any tax imposed under the Internal Revenue laws. Nice. And receive tobacco taxes. There's the Farm Credit System and Homeowners Loan Corporation. The Federal Reserve banks are authorized to act as depositories for the Commodity Credit Corporation, the CCC, and for any federal land bank, federal intermediate credit bank, bank for cooperatives, or other institutions on the Farm Credit System. With the approval of the Secretary of Treasury, Federal Reserve banks may act as depositories for the Homeowners Loan Corporation. That's interesting. And we have the FDIC depository accounts. We know about these, kept with the United States Treasurer, approval of the Treasury with the Federal Reserve Bank, institution designated as a depository or fiscal agent, unless the Secretary waives that requirement. All right. Now it takes us to the best part of the presentation, where we take the fun quiz here and do our knowledge check. Here's how we play this game. In the chat, you'll put the number of the question you're answering, followed by the letter of the selected answer. So, for instance, for question 1, if I was going to select letter D, I would put in the chat Arabic number 1, followed by the letter D delta, and that'd be my choice. If I choose to change my choice, I would just put that same number of the question in again in the chat, followed by my changed choice. That said, let's get started. Question 1. The county treasurer mistakenly collects $50,000 in fees that were never actually owed by taxpayers. The money sits in the county's operating account. The taxpayers demand it back, but the county argues that the funds are now private property since they were collected in error. We saw this in the beginning of the presentation. Who is the proper custodian of these erroneously collected funds? Now, it sits in the county's operating account. A, the individual taxpayers who pay since they are the true owners. B, the state in whose name and authority the funds were pretended to have been collected. C, the county treasurer personally as a collecting officer. Or D, no one. The funds revert to the federal government. All right, anyone wants to take a chance at answering question 1? $50,000 in fees that were never actually owed were collected. So the county treasurer mistakenly, yeah, right. The money sits now in the county's operating account. The taxpayers demand it back, but the county argues the funds are now private property since they were collected in error. So who is a proper custodian of these funds right now? There's 50,000. It's sitting in the operating account, but who is the proper custodian? Is it the individual taxpayers? Is it B, the state, whose name and authority the funds were pretended to have been collected? Is it C, the county treasurer personally as a collecting officer? Or no one, the funds revert to the federal government? Anyone wants to take a chance at question 1? Come on, this is an easy one. All right, going once, going twice. If you want to answer later, you can, but we're going to question 2. Question 2. City National Bank is designated as the official depository for Riverside County. The bank's surety bond was executed on March 1st, but the county treasurer had already deposited $200,000 of county funds in the bank on February 15th. The bank later fails.
Fertarol says, I see.
All right, we had 1 C. Let's go back here just to verify which selection that was. Oops. Wrong way. There we go. All right, the county treasurer personally as a collecting officer. Okay. All right, back to question 2. Anyone else for question 1 before we move on? All right, the bank failed. The bond was executed March 1st, but the deposit was on February 15th. So the surety or the bond was executed after the deposit. Can the surety on the bond avoid liability for the $200,000 before the bond was executed? A, yes, sureties are never liable for deposits made after the bond exists. B, yes, pre-bond is considered a loan, not a deposit. So can the surety on the bond avoid liability? So can they not be liable? Yes, they cannot be liable. That's what we're saying here for A. The sureties are never liable for deposits made before the bond exists. It was February 15th when the deposit was made. The bond was on March 1st. So B, yes, the pre-bond deposit is considered a loan, not a deposit. Is it C? No. If the bond terms are ambiguous about the coverage, sureties are liable for prior deposits. Nowhere in here does it say there's some other terms, so yeah. Or D, no, the surety is automatically liable regardless of any bond terms. So which one is it? City National Bank failed. $200,000 was deposited on February 15th. Bond was executed March 1st. Then the bank fails. Now the surety, you go to the surety, like, hey, you're supposed to be covering our deposit. Well, are they going to avoid liability? Yes or no is the question here. We have 2 for yes, 2 for no. Only 1 is right. Anyone want to take a stab at question 2? We're going to move along to question 3. Going once, going twice, going 3 times. And we're on to question 3. Greenfield Township issues of $5 million in bonds to build a new water treatment plant. With construction delayed, the Township Council votes to temporarily redirect $1 million of the bond proceeds to repave Main Street, promising to replace funds once the state budget arrives next quarter. Is the temporary diversion of bond proceeds to road paving lawful? A, yes, the legislature has plenary control over all public revenue in the Treasury. B, yes, temporary transfers are always permitted if the funds are replaced promptly. C, no, bond proceeds raised for a designated purpose cannot be diverted, even temporarily, until that purpose is fully accomplished. Or D, no, but only because road paving is not a legitimate public purpose. All right, this one here should be pretty easy. Again, 2 yeses, 2 nos, only 1's correct. Anyone wants to take a stab at question 3? We only have 1 more to go, so take your chances now. Going once, going twice, going 3 times. All right, we're on to question 4.
Vicious says, capital C.
All right, so we got a C, and that's on question 3. Let's go back here really quick. There must have been a real delay here on this live stream. So C, no, the bond proceeds raised for a designated purpose cannot be diverted, even temporarily, until that purpose is fully accomplished. Okay, good answer. And we're on to question 4. First Federal Savings Bank, an FDIC insured institution, applies to become a depository of a federal public money. The Secretary of the Treasury approves of the designation. The bank asks whether it must post a security bond to cover the full amount of all anticipated federal deposits. What security is required for the insured portion of federal deposits at the bank? A full surety bond covering 100% of all deposits, insured or not. B, no security is required for the parts of deposits that are insured deposits. So it's an FDI, but it's up to like 250,000 or something. I don't know, but it's definitely not going to be all the money. C, only a letter of credit from another FDIC insured bank is security required. Or D, a pledge of U.S. Treasury bonds equal to twice the insured deposit amount. So what security is required? A full surety, no security, since it's insured for the parts of the deposits that are insured. C, only a letter of credit from the FDIC insured bank, or a pledge of U.S. Treasury bonds equal to twice the insured deposit amount. All right, this is an easy one. Someone please take a stab at this one here. Question 4 applies to be a federal depository here, and they're approved. What bond must they post? All right, we're going to go on to the answer slides. Going once, going twice. All right, let's get to the answer key now. For question 1, the county treasurer mistakenly collects that $50,000. And the county argues the funds are now private property since they were collected in error. Who is the proper custodian? The correct answer is B, the state, in whose name and authority the funds were pretended to have been collected. So the public funds include money erroneously collected under color of office. The state's the proper custodian, even though the money belongs to those who paid for it. They're the proper custodian, they're the trustee, but it's not their money. They're holding it for the beneficial interest of those who paid it. All right, so do we answer on question 1? I don't think anyone, okay, so yeah, you see here it was B, because even in error, the state then becomes just a trustee of those funds. All right, we're on to question 2. Correct answer was C. This is City National Bank surety bond executed March 1st, but the county treasurer deposited $200,000 on February 15th and the bank fails. The correct answer is, can the surety bond avoid liability? No. If the bond terms are ambiguous about coverage, sureties are liable for prior deposits. So this is very different than most cases with sureties, but that's only when it's ambiguous because, again, the statutes and the constitutions usually are going to override that. When the bond language is ambiguous as to deposit coverage, sureties are held liable for deposits made before execution. All right. So that was question 2. And I believe that's question 2 you were answering there. Excellent. And let's move on to question 3. Question 3, the Greenfield Township issues $5 million in bonds for a water treatment plant. With a construction delay, can they divert it to the repaving of Main Street, just $1 million of it, partial? And the correct answer is C. No, the bond proceeds raised for a designated purpose cannot be diverted, even temporarily, until it's fully accomplished. Actually, I think you're answering this one here for C, but we'll give you both of you. Both of them C. All right. Bond proceeds in the nature of a trust fund cannot be used for any other purpose. So you just think of bond proceeds. Bond proceeds are basically in a trust fund. So they can only be used for the purposes designated in the trust, permanently or temporarily, until the designated purpose is fulfilled. All right. And finally, question 4. Correct answer was B, the First Federal Savings Bank, designated as a federal depository. They ask what surety bond to cover. And B, no security is required for the parts of the deposit that are insured deposits. So that's the security required. It goes above those FDIC insured deposits. The Federal Reserve Act exempts insured portions from the security requirement. Only uninsured amounts must be secured. And that was from our later section there, where our eyes are glossing over. This has been quite a long, deep dive into public funds, but indeed a very illuminating one to see where all this money that's coming in as public funds, these public officials have a lot of people grabbing at them, asking them for, please let us be a depository, let us manage those funds. At the same time, you're finding a lot of mismanagement for reasons where banks are failing, public funds being misappropriated or miscollected and not redistributed. Who knows where it goes from there? But that time delay also is something where people can profit, both from interest and from diverting to other purposes. So as we can see here, quite a complex issue here, quite an important one when it comes to something that is such a large scale that without our attention, it could certainly run amok. So salute to you all for being here to learn a little bit more deeply about the public funds, how they're used, deposited, and transferred, and the correct way to be doing it so that we can make sure we can hold those that are in trust with the public funds accountable. Thank you all for attending, and I hope to see you all on the next one. Peace out.
The crime says, hit the like.